Alright, Miss Ward here. I'm going to try and do a video on Chapter 9 from Family Law. Chapter 9 deals with physical and legal child custody and also with visitation. So we're going to start out looking at the difference between physical and legal custody. Legal custody involves the authority to make major decisions for a child concerning the child's welfare, medical care, education, religious participation, etc. If there's joint legal custody, then neither parent should make major decisions without consulting with the other parent. The exception for this is in cases of emergency, obviously. Physical custody, as opposed to legal custody, looks at who the child resides with and who is responsible for their day-to-day care. We usually describe that parent as the custodial parent, and visitation normally happens with a non-custodial parent. Visitation normally does occur even when there is sole custody with one parent, unless there is some good, compelling reason why visitation with the other parent should not occur. Okay. Physical custody can be sole. It can be joint, where the child resides with and is under the day-to-day care of both parents. We usually describe it as the child having a frequent and continuing contact with both parents. Okay. The preference in modern courts and modern family law is for joint custody. Okay. The other option for physical custody besides sole and joint is split custody. And this is where between two parents, one parent has custody of some of the children, and the other parent has custody of other children. Courts do not favor split custody. This is a situation where mom and dad divorce. Dad has custody of maybe the son. Mom has custody of the daughter and the youngest son. So courts prefer, when possible, to keep siblings together. Okay. Again, if there is some good cause, then split custody is an option. Okay. I'm going to show you my notepad here again. I've written down the legislative measures that are covered in this chapter: the UCCJA, UCCJEA, the PKPA, and the Hague Convention on Child Abuse. Okay. Also, I want to call out to you, there's a case on page 313. It's Rainbow versus Ransom. There's an excerpt of it in your textbook, but there's also a link to where you can go to read the full case. Moving on, my teaching assistant is getting bored. I want you to look at some of the standards for determining custody. These are some of them historic standards, starting back with a paternal preference, where fathers were assumed to have custody rights over their children in the event of a divorce, followed by a maternal preference. We also have what's called the tender years doctrine, which basically said that for young children, infants and toddlers really, that the mother was the best caretaker. For the next one, we have the best interest of the child, and that is a predominant standard today. Okay? It looks at who's better able to meet the needs of the individual child. Okay? We also have primary caretaker presumption. Under that standard, the court looks at which parent has been the primary caretaker of the child during the marriage, that is prior to the divorce. And they award custody responsibility based on that. Lastly, we have the ALI, the American Law Institute approximation rule. So it's the one that American Law Institute has suggested that states adopt. Again, states make their own choices regarding which standards their courts will use. But the approximation rule basically tries to come up with a percentage of how much each parent contributed during the marriage to the caretaking responsibilities. So who got the child dressed for school, who bathed the child, who cooked the child's meals, other things like that, who took the child to basketball practice or football or ballet. So all of those types of things are looked at under the approximation rule. They try to divide up custody based on the same kind of percentage. So it's more of a mathematical approach to shared custody. Moving on, factors when considering custody and visitation agreements. These are things that the court will consider. One we just talked about, which is caretaking activities by the parents. That is involvement in the child's day-to-day life. Availability of the parent, both in terms of work schedule and work locations. Stability of the parents in terms of residence and jobs. Race and gender are factors, but look carefully in your textbook about how those factors can be considered, because there are certainly ways that they cannot. Religion, there is a case, Kendall versus Kendall, on page 323 of your text. It doesn't tell you in the text what the outcome is, but it gives you a link where you can look it up. Okay. Parental health and disability. So this is normally not a factor that would prevent or limit visitation or custody, unless it was something that would prevent them from being able to properly care for the child. Okay. Sexual conduct of the parents, parental lifestyle. So these are sort of getting at things that may or may not be appropriate for mental, physical, emotional well-being of the child. And history of abuse, and finally the child's preference for who they'd like to spend the majority of their time with. So those are some factors to look at. There is also a case dealing with race as a factor in custody. It's a U.S. Supreme Court case. It's right here, Palmore v. Sidoti. It's on page 321. Just take a look at that one, please. When you're looking at visitation issues, primarily we're looking at the difference between supervised and unsupervised visits. And you can look in the text for some of the reasons that visits may need to be supervised with a non-custodial parent. Finally, take a look at modification of custody orders. One thing that's really important for law offices to advise their clients on is the not permanence, but the difficulty of changing custody agreements. So it may be tempting for a potential client to say, well, this will work for now, and we'll change it when things change. But it's not generally easy to modify a custody agreement. Now, if the parties are getting along and are on good terms, then they may be able to informally just agree to modify visitation schedules or even day-to-day custody. But chances are they're not always going to get along. Okay? If they got along very well, they probably would still be married. So it's not a good idea for clients to have this concept that they can just change a custody agreement. There are limited circumstances when you can modify custody agreements. You have to file a petition or a motion to modify custody. Courts can restrict when custody can be modified. Often they are unwilling to modify custody agreements for a certain period of time, 2 years perhaps, in order to help with stability. If you think about it, the process of reaching this custody agreement that's filed along with the divorce settlement is to provide stability and understood rights and responsibilities for the family unit moving forward after the divorce. So you don't want to make it too easy to modify. So that being said, I think that will wrap up Chapter 9. This is a little bit longer of a video than I've done before, so I am hoping it doesn't take a long time to upload. Appreciate your attention. Again, if you've got feedback, I'm still playing with YouTube, but if you cannot hear me on the video or you got a suggestion for me, put it in the comment. I do seem to be able to see those, so thanks a lot.